Any questions so far? Yes, sir, please.
So when both party compromised in mediation, is that justice really served?
If that's what they want, then why not?
नहीं सर, मतलब both party compromised in mediation, तो उनको justice मिलता है? जो mediation में वो compromises करते हैं, उस compromises के बाद उन्हें justice मिलता है जो वो चाहते हैं?
That depends. What is justice? How will you define justice?
So according to their needs, जो भी वो mediation में जा रहे हैं जिस वजह से.
And that's what they get in the settlement. They agree on that. If they don't agree, if they think that they did not get justice,
so mediation में तो फिर वो कुछ solve ही नहीं हो पाएगी ना उनकी problem अगर वो settlement ना हो तो.
Not all mediations end in settlement. Not all. If the parties think that they are not getting justice, they are free to walk out. No one is making them stay there. I hope that answers. Thank you so much. Anyone else? Yes, please.
Sir, what is negotiation and how is it different from ADR?
Negotiation, as the word says, is just negotiating between two parties. I hope you do know what negotiation is. But the negotiation part in ADR, if you see Arbitration Act, Mediation Act, it has not mentioned. It's just negotiation. And negotiation as a career would be applicable between, as a lawyer majorly, when you are negotiating on contracts, you are entering, there's MOUs, mergers and acquisition, but not primarily in ADR. I mean, you can negotiate in mediation as well, what you want, what you want to get out of the problem. So that's negotiation for you. Do you want to add something?
Last night, this came up last night actually, a really good example of it to illustrate the difference is the Trump-Zelensky exchange that we saw. As shocking as it is, nobody really likes looking back at it. That there was a difference between whether you believe him or not, that you've got Trump who likes to consider themselves as the good faith neutral mediator, but at the same time he's negotiating for this minerals deal, and you can see there was the threat. So I think the simplest way of it saying is where you don't have an interest. I mean, you may not. Obviously, if you're counsel for a party with an interest in a negotiation, it's not your interest, it's your client's, but you're one and the same in that regard. But mediation is truly, you're there to have as a neutral party. You don't have an interest. At the end, look, my only interest as a mediator is to help the parties get to a resolution. If they don't, is it my problem? No, I can sleep at night. I honestly, I mean, I'm disappointed. Fortunately, I have a reasonably good success rate, but that's not the point. I mean, what bothers me is if I get frustrated when they can't see what stands right in front of them and you can't help them see that. And part of what your job is to, give them different perspectives and see things differently, because they've been seeing the dispute probably from the same way for the last couple of years by the time they get to you. So you need to be creative to allow parties to see things, their strengths and their weaknesses from a different perspective. But no, it's the parties' mediation. Can I ask you a question? Two propositions. There's an A and a B. If I gave you option A, you have a dispute. It's going to take you a year and a half, maybe 2 years, cost you the best part of this is an international contract, but I can handle those numbers. I can't deal with lax. It always confuses me. And it's going to cost you $1 million to go through. That's your option. You get an award. It's a favourable. If you know it's in, well, you don't know. There's an award and you don't know what's going to come. You've got that. That's your option A. Or option B, you can resolve in, say, 6 months. It costs you a fraction of the money, let's say $100,000, just to round things up. And it not only resolves the current dispute, but a whole host of other potential disputes. And it may give you potential for further work going forward. How many of you here, please put your hands up if you would go for option A? Who would go for option B? Oh, that's not unanimous. Is that not everybody? Some people being very shy. Okay, let me just add just for option B. And if I told you there was a 90% chance of you getting what you want, who would go for option B? Right. I'm okay. I've missold it. But essentially, that's the difference between arbitration and option A is arbitration, an uncertain outcome that costs a lot of money and time, as opposed to a much cheaper outcome that's actually a better outcome. It's not the binary dispute. It's actually all about parties' interests, and I think that's where it has a massive difference. And I'm pleased to say I think you'd be the arbiter of this in terms of, I think the majority certainly put their hands up, but it wasn't unanimous, which is where we need to go. But obviously there was a big difference between option A and option B, and that's where the focus needs to be. And as I say, a lot of this is timing. The two, it's not, and in reality, it's not A or B. You run both together and at appropriate times. But that's another aspect. Okay, sorry. Any more questions? I know this chap had a question about arbitration, but
Yes, please.
Sir, how much can a mediator earn after, let's say, 10 years of practice?
That's a good question. So as
Sir,
per Delhi Mediation Center,
will I be earning more than my lawyer friend?
I don't think so.
A normal
To be
litigator.
very frank, generally what happens is in courts, so they have the lawyers are only the mediators in courts, so they have their days marked, like from let's say Monday to Wednesday they'll be practicing. On Thursdays they'll have to sit as a mediator. On Fridays they can again appear in court, and Saturday, Sunday they can do their chamber practice. And the mediators don't get anything, but they get an honorarium of some sorts. If you see the private mediation practice, a mediator can up to around 30 to 40,000 for per case basis. But then again, the case will get resolved in a week or so. At least that's the hope. So you can have multiple cases. So that truly depends upon how good of a mediator you are or how bad of a lawyer you are. Your salary or your earning will depend upon that.
So that means the bad lawyer will always become a mediator.
Sorry, was that?
So that means the bad lawyer will always become a mediator.
You want to answer that?
I'm just trying to say that means that the bad lawyer will always become a mediator in that case.
I think there's some truth in that, that's for sure. It depends where you're talking about. In the US, I think it's true there's a universal problem that mediation and mediators are undervalued. And so the rates are very low. I've never, there are a handful who make a living out of it in the UK. A lot of them are doing it kind of part-time, and none of them are going to turn around to you and say they're overpaid. They're far from it. In the US, they can make some serious money. Comparable with being a litigator or an arbitrator. So the as a career, it's a valid question. But I think the nice thing about mediation, a lot of people do it not just for the money. Of course, I think there is something about the philosophy of mediation, the love of mediation, to want to do things and almost kind of give something back, rather than doing it in the old traditional adversarial way of doing things.
Is it because that the world is not really acquainted with this mediation and all that so much as it would be up 10 years from now? Would that make a difference?
You want to?
Well, I'm sorry, because these are so interesting. I wouldn't put a time limit on it. We've been going at it for 40 years, at least, maybe 50 in the UK, and we have our own issues. There seems to be a ceiling. You would hope, as people get involved, get engaged, that they will see the benefit that comes to it. The saving to the business, the saving to themselves in terms of the emotional wear and tear. You would hope that the value goes up. You have to be a little bit careful, and there is a bit of a chicken and egg situation. You can undersell yourself, because once you start off on a low rate, it's very hard to kind of go up. But it depends. I do, as I say, the US is very litigation heavy, and they may complain about it, but they value legal services, and that's part of that umbrella. And there, as I say, there's a handful of mediators that work very well. I think the answer is time does help. But whether it's a year, 5 years, 10 years, 40 years, it's a long path. So I think the great thing is, hopefully you might be coming to the party late, but you're coming, I think, quicker with a greater energy. So, and you can learn from the mistakes of other jurisdictions. But sorry, did you want to?
And personally, from an Indian standpoint, I'll give it 10 to 15 years before it gets.
Oh, you're going to put a number on it.
Yeah.
Okay.
See, no, the thing is, right now, mediations are done majorly in family disputes, but we have commercial courts act, we have mediation act, and I'm a very optimistic guy, so I'm going to say 10 to 15 years.
Anyhow, it's going to be better every year.
I mean, we always evolve with time. So even the Arbitration Act came out in 1996. It was not perfect, and we are amending it almost every year or so. From 2014, every 2 years or so. We currently still have a pending draft of amendment bill. So yeah, we'll evolve. Yes, please.
Sir, is there a possibility of mediation in criminal cases?
We have that sort of thing called plea bargaining, and if I remember last year, we had Pascal here. If you had, so he does mediation in criminal cases itself. So the question could be very good for him.
Yeah.
Yeah, please.
I was going to say, no, I'm straying way out of my comfort zone. There is something called restorative justice, where you see, where there's been militia issues, crime as well. I think the US is leading that way. I've heard of it. It's complex and difficult, and I mentioned it before. It is a very broad church. And what makes you a good family lawyer, a good criminal mediator, is very different from what might make you a good commercial mediator. And so there are all these little nuances as well. There is no kind of one size fits all, although superficially it does look like a lot of the skills you're required can be applied to anything. But I think where you add real value is actually that expertise that you bring to the party in whatever sector it is, whether it is family, energy, whatever. I'm conscious that this gentleman, I don't want to forget, I'm also conscious of time. I don't know who's keeping an eye on the clock, so we'll keep going as long as we have questions and you're happy for us to go. But so yours was arbitration.
Yes.
Oh, no. Okay. No, okay.
There isn't a positive image in our head. So what's your take on it?
Can you repeat, please?
When we talk about mediation, there isn't a positive image in our head. They are always a hesitation, yes, no type situation, when we go for it or not.
I actually didn't get the question.
It's not a positive image, I think, of it. You don't have a positive image of mediation. Is that right? Did I understand?
No, general public has a negative side of mediation type image in their head. So what's your take?
That's a PR issue we are facing. That I think comes from our history and our society, which is majorly a patriarch, where let's say if we have a dispute in our family, we'll tend to go to our grandfather or grandmother. If we have some sort of dispute in our neighborhood, we would want to go to our, panchayat system, our sarpanch. So we are more than inclined to, listen to those people who have some sort of authority over us. So if we have disputes, we'll go to a judge. So that's the thing which is currently changing with our more, we are getting a very modern society. And the whole, as Joe also mentioned, ADR is basically privatization of litigation. You get to decide your own future. And with time, people are understanding this thing. You want to add something?
Yeah, absolutely. I mean, you've hit on a point that I feel quite strongly, and I like. I'm not trying to be provocative or controversial, but I think it's missold, mediation. And I think part of the problem is because we just think it's one thing. And I think mediation in the family context is very difficult. It's very different from a commercial context. And the reality of it is, I don't do family mediation. That's really not for the faint-hearted, very complex and difficult because your emotion is clearly running high, generally speaking. There may be business behind all of that, but when it involves a family, there's another level. You still have emotion in commercial contracts, but not to the same degree. I genuinely feel, and I increasingly every time I say it, I think I say it more robustly. I think it holds us back in the commercial context to keep talking about this consensual, amicable resolution, because the reality of it is people are in dispute. They're not friends. They're not being consensual. They don't want to agree about anything, time of day or anything. But actually, they're not stupid either. And if people are pragmatic and cooperative, they realize it's in their own self-interest collectively to get together. So I kind of push back with this kind of warm, cozy, hug a tree, kind of slightly hippie view of mediation, because it sounds so much like meditation. It's not. Some of the worst or most aggressive exchanges I've ever seen have been in a mediation. And I've seen a few of these. But it's cathartic. I mean, you run a risk. Somebody might go screaming out of the door, but actually they've got an opportunity to do that they will never have in a court of law, or very rarely, or even in an arbitration. So I think I would use much more positive terms about constructive, collaborative, pragmatic mediation rather than consensual, and because I think the reality is it then has that sense, well, it's only for really small matters, not important. And then when you get into the nitty-gritty of it, mediation gives you the opportunity to create, we've mentioned this several times, both of us, to create your own settlement. Way more than in a litigation, that's the judgment. That's the issue. I decide in your favor or I don't, or some kind of fudge, but that's it. Whereas you have the ability to create a really constructive, pragmatic way, either to resolve the dispute and move on, or to at least kind of then put the water under the bridge and move on together. And it's particularly, you hear often said, useful when you have ongoing relationships. And often there are big projects. Constructors will have their contractors. They don't want to just walk off and never work for them again. They need to resolve an issue. So it's much more pragmatic, I think, than it should be. But there is a perception issue. There is a PR issue, and that's why you, sir, and all you are very important in spreading. I think you need to convince yourself. At the end of the day, don't take my word for it. There are statistics that back up what I'm saying, but I think you have to begin to believe in it yourself. And not the great thing about you guys, you don't come with a baggage like an old guy like me does. So you can come in it and actually say, wow. And I found it quite late in my career. I was quite down the road. You're starting yours. And if you're starting yours now with that kind of positive mindset, that is not the panacea, as I say. It's not for everything, but at least you think there is this other option that we can explore. Is it appropriate to explore? And always come back to it. It's not just the one time I looked at it once, I can tick that box. I think that's really important. And that's why I was very keen, and hence the question about it's not just lawyers, but it starts with us. We need to engage our colleagues in the commercial world. Those are going to be clients. And I think there needs to be a better discussion in the general public. It's not exactly the sexiest topic in the world, I know, how you might do that. But it's something that we need to bring higher profile and not just accept that perception. But you're right. I mean, I'm not going to dodge it. It's hard. Thank you for the question.
What future does ADR hold in India and globally?
What
future does ADR hold in India and globally?
Yeah.
Okay.
Future.
I think I've already answered that in last couple of questions, that we are currently into a very golden age of ADR in India and globally as well. There are a lot of career opportunities. People are preferring more and more ways of resolving methods through alternative means or appropriate means. We are amending arbitration acts. We are passing mediation acts, and Mediation Council of India is just on the horizon. So there are very good positive career which are going to be. And would you want to say globally?
Yeah, well, I think certainly, I mean, Indians are like their cosmology, and I think the stars are all starting to come together in a way. It's not, there's a window of opportunity that for you to seize. And I think that's why, I mean, the current guys, but you will be not far behind them. I think there's a real, I'm optimistic for you. So I think the future is positive, both for arbitration. As I said, there's no reason whatsoever that India really shouldn't be able to become an arbitration hub or a mediation hub, but it won't happen just because you have a great act. It has to, you need everything, all the stars all need to be aligned. The judiciary need to get on board. The law needs to be in place. Council needs to be in place. Clients need to be in place. All the stakeholders. And you can't start too early with that. So I think it's very positive for the future. Of course, if you're talking about AI, AI is here. It's not coming, it's here, and that's going to become ever more dominant, and that's how we use it. I think it's a force for good at the minute, I don't think we're going to get all wiped out just yet. But that's clearly going to change things. The technology, COVID forced us to go online, and that's had huge benefits, I think, to a large extent. We've kind of come back, I think, to a hybrid world, which is probably the right place to be. So technology is certainly going to be, and that's what you're seeing globally around the world. The one thing I would say and can predict, sadly, without really much doubt, we're going to continue seeing disputes all over the world, and they're going to grow, not go down. So it's just how we deal with them. That's a bit depressing, isn't it? Good for lawyers.
Sir, is ADR always cheaper and faster than court proceedings?
That depends.
Somebody had to say the word depends.
Yeah. So you asked ADR, and if we talk about mediation, then yes. If we talk about arbitration, then that depends. Arbitration, you have to hire a lawyer and you have to pay the fees of arbitrator, which is always huge money. It's an investment basically. So if you go into mediation, then yes, it will be cheaper. If you go into arbitration, that depends upon case-to-case basis. You want to add anything?
Well, only to the extent I would say that a lot of the work you do for mediation, if it doesn't settle, is work you would be doing anyway. So it's not, and really there's very little additional cost. And it's worth investing that additional cost, I would say, to save yourself potentially a whole lot of money going forward and time going forward. But again, it does depend, because you may have in certain jurisdictions very quick court procedures, summary judgment procedures. If we're looking at India specific, it depends where your dispute is. I'm coming from the international context, and it may well be that you have court systems that are available that are actually certainly quicker or cheaper than going down the arbitration route, although you still may have issues about appeal and other disadvantages of pursuing the court.
Anyone? Yes.
He's got.
So I have a question, Joe sir. So what is the process to become your intern?
This guy. I've applied to be his. He won't take me.
I'll consider.
Well, you're asking a little the wrong guy. I've now retired in terms of I'm kind of on my own, but it's a valid question that you need to look out for people. Sir,
don't you think age is just a number?
I like to think so, but the way you see me dancing the other night, you probably realise that I'm beginning to feel it. But no, I think seriously, is looking out for mentors. I think, forgive me if I've said it already, but there is no substitute for experience at the end of the day, and applying what you're learning in a real world context. And so the moot courts are, they're candidly a bit artificial, but they are great to kind of give you that, at least a sense of the mechanics of it all, and getting involved with things like that. But if you can get ideally a mentor and become their assistant, fantastic, or tribunal secretary, that's a really good one, I think, when you're starting out. But I don't want to belittle tribunal secretaries. I've seen partners from very senior firms be the tribunal secretaries for even older, more senior part. It's an important role, and I personally think it's well underused on the circuit for arbitration. Mediation, again, you can go. That's an easier one, because you don't have the confidentiality issues really that you might do in a. You have to sign a confidentiality form, but you can go in as an observer. I mean, if you can attach yourself, maybe go down to the Supreme Court and sit there. Whoever say, "Look, can I come along and sit in on this mediation?" That's good. That's experience. I mean, you're not the one necessarily making the decisions, but you're seeing this and being able to say to somebody down the road, "Well, I've seen 10 of these." You're going to stand out from the rest of the people. Is that the dean to say our time's up? What's going on? Where are my students?
Anyone else?
Where is the faculty? My goodness. Yeah, right.
So, anyone else? All right, I guess we can take a seat.
Yeah.
Introduce you all to Honorable Professor Dr. Rakesh Khurana, sir, advisor at MERI Group of Institutions. He would kindly sum up today's session and deliver a vote of thanks as well. Just to let you introduce to him, he has been the Pro Vice Chancellor of IGNOU and the Founding Director of the Electronic Media Production Center at IGNOU. He was also the founder and the chairman of Knowledge Network India Limited, a pioneer e-learning company established in 2000. Additionally, Dr. Khurana has served on boards as the chairman of academic councils at various esteemed institutions, including MERI. I request you all to please join me in extending a warm welcome to Sir. I request you, sir, to please come forward and sum up the today's session and deliver a vote of thanks as well.
First of all, I would like to thank Joe and Param to, what shall I say, to keep us updated in terms of what's happening. A number of questions are related to that. As budding lawyers, you also have to figure that it's a very crowded field in India, and it is better to figure out some niches, and this is one of the niche. Now, I learned something new today. I don't know how many of you came for the previous lecture. Earlier.
So many of them are.
Yeah. Now, the earlier lectures we had edited them. They are available on the video. They are available on our website. Outsiders have been seeing it, and we get the statistics these days. Analytics are very easy. But not enough students saw it before coming for this session. If they would have had sharper questions. Because we can otherwise go to online and listen to what Param has to say. Not one lecture, many lectures. He goes to a lot of places. When we take that time to come, and in traffic like Delhi, somebody is coming from outside and taking the time out, we should take advantage of every minute of this. And their questions, the answers to the questions will be as deep and wide depending on how the questions are. If you ask very ordinary questions, you will get very ordinary answers, right? So not just for this session, we will be making this. They'll be happy to respond to your questions even afterwards, right? Once you have seen those tapes again, please make that as a habit. That's one. Second, I am from management and economics and electronics engineering background, not a law background. But you should observe economic environment, social environment like anybody in the management school. And what are the basics of it and what are they changing? Have you heard there is the first court, I think it is in Chandigarh, which is going to be online court only, 100%. And there's hardly few places in the world where they have only online court. So in India, while we are slow on certain aspects, we are also quite fast on some other aspects, right? We have set up family courts, we have set up small causes court. It's not that they have not responded to this business of, so many cases and, so many dates coming. So pendency keeps on going up and all that. But the online methodology can sort it out. Let's see what happens to this Chandigarh court. And things will improve. Second, mediation and arbitration, especially in the corporate world, will go at a very fast pace in the online because the cost of the executive is coming there to argue things, right? Cost of those lawyers in terms of number of days, number of hours, etc. is very high. Third, a point which has not come up, it's because a question is not there, that what impels the companies to go for these things? They have a dispute. I know a lot of contractors who have these disputes with the DDA and other PWD and so on and so forth, but they don't want their quote-unquote trade secrets to come out. The issue of technology, if it is Microsoft or it is Google or somebody and they are sued in Eastern or EU, they would rather than still settle it outside the glare of the media and outside the glare of the open courts, right? So they sort it out. Therefore, naturally, as the technology becomes the most important factor, right, that becomes the capital, right? There will be more and more, arbitration and mediation. Param said something very nice, that our pendency, etc., is in the urban courts. Our rural and semi-rural areas, still, the justice is done by the head of the family or head of the community, right? Like the sarpanch. So they will award a sentence, and normally that sentence will be restorative justice. Somebody has got killed. This is the economic cost of that person for the life, whatever it is. So 1 lakh rupees, your family will have to pay. Maybe not that person, to take care of it. Somebody's got hurt, leg is hurt, he can't work. 50,000 will have to be paid, and it's paid. Still it goes on, and unfortunately we are kind of going away from it. And the current mediation and arbitration is a substitute for that, actually. Be that as it may, we should learn to learn. We should form a base to learn lifelong. And Param was very diplomatic. He did not answer the question of interns. Let me say on his behalf, yes, they are always looking for good chaps, good girls, boys, to be interns. And there's nothing like in this profession to learn by actually observing and participating. So do try. There are some other firms also, but Media Guru, because they primarily rely on online methods, I think. Yeah. So that is style of the future. With this, let me thank them for taking the time out. Hopefully, we will have more opportunities also. We will make this seminar bigger and bigger and make it a regular annual, semi-annual affair. And all the students for coming. Thank you.
With this, we come to an end of the seminar on Alternative Dispute Resolution, a Progressive Approach to Justice. We extend a sincere gratitude to all the speakers and attendees for their active engagement and insightful contributions to this enlightening seminar. Your insights and discussions have undoubtedly paved the way for more profound understanding of the ADR and all such seminars. Thank you so much for being here, and thank you so much all the dignitaries and the guests for being with us today. Thank you so much. Have a great evening.